You know what?
Hey, everybody. This is Christina Previtt. I'm the CEO and managing attorney, one of the managing attorneys of New Jersey Divorce Solutions. And I am here today with Lauren Bercik. Lauren Bercik is the owner of Bercik Law, a law firm with offices in New Jersey and New York, focusing on wills, estate planning, probate administration, and estate litigation. Hi, Lauren.
Hi, Christina. Thanks for having me here today.
Thank you so much for joining me. We're going to talk about something that comes up from time to time in my divorce practice and just generally in my travels. It's the one thing that I think we're doing a public service by talking about it briefly, because I think a lot of people think that they don't need a will, whether they're married, divorced, and that's the subject today. Whether you're married, divorced, single, or living together, you do need a will, and Lauren is going to tell us why that is. So, Lauren, why don't you first introduce yourself so we know what your background is?
Thanks, Christina. Again, I'm Lauren Bercik. My practice focuses on estate planning, guardianships, probate and estate administration, as well as estate litigation, where I'm located mainly in Shrewsbury, New Jersey, and Monmouth County, but we do cover all of the counties in New Jersey, as well as parts of New York State as well. My practice has been in many areas. I was a registered nurse for 20 years before I went to law school. I graduated Seton Hall School of Law in 2004, and I've practiced in the areas of personal injury and medical malpractice litigation. However, I've spent the majority of the time practicing in the areas of elder law, probate, and estate litigation. I've recently completed the New Jersey Rule 1:40 mediation training program, and I'll soon be offering mediation services to help families resolve probate disputes without having to go to litigation or potentially a trial.
And so that is actually going to lead us to why it's so important to have a will, so that you don't have all of your relatives fighting over your estate when you're not here anymore. Although maybe you don't care, because it won't be your problem when you're gone.
I do care.
Before we even get to that, can you just tell us, what is a will? It sounds really basic, but can you explain what it is?
Yes. A will is your final wishes, your final, or what they'll call testamentary wishes, what you want to happen with your estate at the time that you pass. The will would be filed in the county surrogate court where you were a resident at the time that you passed away. It would appoint an executor, which I like to call the captain of the ship, who would administer the estate and take care of the assets, wrapping up any final debts and so forth. And ultimately, if there is a dispute, the court can enforce your wishes.
Okay. And I know a lot of people will think that, it's not that complicated. I don't own much. I don't have anything. I have like an awesome t-shirt collection and that's about it. But I don't want my relatives fighting over that. So, we'll talk about more about why it is important, even if you think you don't have anything, and highlight those things for the people that are watching. But I think an assumption I hear a lot is, if I die, my spouse gets it all, or my kids are going to get it all. So is that really true? And in your opinion, is that a dangerous assumption?
Well, it is a dangerous assumption. If you don't have a will, or a valid will, because we'll also talk about when sometimes people like to make their own will or copy and paste things off of the internet, where it may be they think that it's valid only to find out that it's not at the time their loved one goes to probate it with the surrogate's court, because it doesn't meet the requirements of the will of a will in the state that they're in. So if they don't have a valid will, for whatever the reason, they've neglected to do one, or they've tried to do it yourself will that didn't work out so well, as I would say, then all 50 states have a law of what they call intestate succession, which means the law decides who gets your assets. And that may or may not be the same. Now, you pointed out, oh, well, my spouse is going to get my estate. But there are instances where your spouse would not get your entire estate. For instance, if you have children from a prior marriage, the estate would be split between your spouse and those children. And I'm using this as an example because sometimes there's the case where you may have had a prior relationship and you've not seen these children or somehow become estranged from these children for many, many years. However many years you've not seen them, or whatever the quality of your relationship is with your family, whether it would be your siblings, your children, a spouse that's been estranged for a long period of time, there is a law that will allow them to inherit, and it's not based on the quality of their relationship. So if you had one child that was estranged and your other child is by your side and your caregiver, they would still split the estate equally. The law doesn't look at quality of relationship, only the bloodline of the relationship. And you would have an opportunity by making a will to express your wishes. You'd have the opportunity to decide how you want your estate distributed. Who will take care of your minor children? Sometimes that becomes an issue. I've had unfortunate circumstances in my practice where a parent, a custodial parent, is unexpectedly killed, and the non-custodial parent, who may owe a substantial amount in child support and has not been involved in the children's lives, now comes in to take the children, while the grandparents have really been the helping the custodial parent raise the child. So there's issues with who your children will go to if they're minors. Who do you want to wind up your affairs? The person that may be next in line or first in line to be appointed administrator of your estate without a will may not be the best person. For instance, if you're in a second marriage and your current wife doesn't get along with your children from the prior marriage, she may not be the best person to be burdened with having to split up your estate. There's also an opportunity to do tax planning to minimize estate tax if you're in a tax bracket that would expose you to estate tax. Although there's no estate tax currently in New Jersey, there's still a federal estate tax, and there could be one raised again in New Jersey in the future. It would also give you an opportunity to avoid inheritance tax in New Jersey, which is still very much applicable to people who are not your descendants or spouse. You also have an opportunity to disinherit those people that you don't wish to receive any of your assets. As I mentioned before, if you have estranged children or estranged siblings or other estranged family members that would otherwise inherit under the laws of intestacy, you would have an opportunity to disinherit them. There's no other way to do that if you die without a will.
Okay, so that was a lot of really wonderful information, and I think it demonstrates that this actually is much more complicated than people might think it is. So I think you clearly explained why it is a dangerous assumption to just think, well, I'm married, so my spouse is going to get everything. I've seen that happen many times in my own practice, is that the spouse dies, and then there are children from a previous marriage who, are coming around looking for their part of the estate, and there are problems because there wasn't a will. So thank you. That was a lot of good information. And definitely more complicated than I think what the average person can probably just get off of Google, right?
Yeah, and I might add, with families, I find people will identify each other as spouses, although they've never legally married. And that becomes an issue.
Yeah.
I have situations where people call each other domestic partners, but they've never really registered as domestic partners. And that actually changes some of the tax treatment of someone's inheritance. And there's also the situation where someone raises a child as their own, but it may not have been their child.
Yeah.
It's never been adopted. However, that child may call the parent mom, dad, but there's never been a legal adoption. And without a will, that child would not stand to inherit anything.
Yeah. Well, there's also the other problem that we all have, where you just think you're not going to die until you're ready, right? But we all know that that's not always the case, right? So sooner rather than later, we should think about these things. Even if we're young and healthy, we should think about these things and get our affairs in order. And in the unfortunate circumstance that it does happen. You've told me privately in the past that unmarried people and single people have more complicated estate planning than married couples. Can you explain why that is?
Yes, that's a great question. Married couples, in a typical situation, they leave everything to the other. And then on the second of the two of them to pass away, it's split equally among their children. That's the traditional married estate plan. And I find most couples that come in for estate planning do follow that course. Now, in second marriages, there is some deviation from that. But as a first line of inheritance, the spouses leave one, each gets the inheritance of the other, what's ever left behind, or it's jointly owned. It's when the second of the two of them pass that it passes on to their children. People that have no children or no other close relatives or are single, they become very difficult questions. And I find it's more of a, besides the logistics of who will get my assets, is I think they feel their aloneness in a certain way, that they don't have a spouse to pass it on to or a significant other to pass it on to. And I think it brings up some emotional issues for them to have to make decisions to trust people that they may not necessarily be 100% comfortable with or trust to administer their estates, perhaps to become their healthcare proxy or power of attorney, and to bring about whatever the final disposition of their estate would be. So, for instance, if you had an unmarried sibling that didn't have any type of long-term relationship, married or unmarried, and that person dies with assets, they would need to be administered. And the person themselves, it's hard for them to conceptualize who will administer their estate, who will carry this out, because they don't have those close ties that other people that have them would naturally say, my husband, my partner, my child. And without those close relationships, it's very difficult for them to think about those types of things and confront them on a personal level. If they want their assets to go to a charity, what charity it would possibly be. I think also for single people, it becomes even more important to think about who will speak for you while you're alive if there comes a time that you can't speak for yourself. It's unfortunate that people that don't do advanced planning can end up becoming a ward of the Office of the Public Guardian if they're in an accident or they become mentally, physically incapacitated. Someone is going to have to make decisions for them. And although it may be difficult to decide who that would be, it's still better to choose, have the power to appoint someone of your own choosing than to essentially have the Office of the Public Guardian become a ward of the state and have a state employee decide your future and your medical care. And then in the end, what would typically happen is the assets would be sold at the time of your passing to repay the state for its services.
And I'm sure we're not all working really hard to just let the government have everything, right?
Well, exactly. And to me, I think an important part of estate planning, besides the final disposition of your assets and you pass, are at a point where you're elderly and you may not be able to make your own decisions or administer your own finances, that there's someone appointed that you trust. Unfortunately, when there's no power of attorney, there's plenty of people that will befriend the less fortunate and offer to help them, although their motives are less than pure.
Yes. Yeah. So that leads me to the question, which I think you've partly answered already, is what would you say to people who have the attitude that, you know what, who cares? I'm going to be dead. I'm not going to be the one that has to worry about it. What would you say to those people?
That estate planning, making a will, even the most simple will, is the best gift you can give your family, whether it's a spouse, your parents, or your children. Writing down your final wishes allows them to have some type of roadmap and guidance during a time of grieving and loss. If you don't want to deal with it, explore with yourself the reasons why. Perhaps there's some conflict between your children and you don't want to have to choose or face whatever their conflicts are. However, what will happen is they will escalate the conflicts after you're gone because you haven't dealt with it. By working through those issues with an experienced estate planner, you can get some guidance and some final decisions on paper that will give them the roadmap as to what you want done, because they'll fight amongst themselves what you would have wanted. And they may both believe that, but what they both believe you've wanted are completely different things.
Well, I think I would strongly encourage anyone who's facing these issues right now, if you haven't done your estate planning, or maybe you need to reevaluate your estate planning, to speak with Lauren. Clearly, she's very knowledgeable. She does litigation, so you see what happens when there is a disagreement. So I would think that your insight is valuable to help people evaluate what things can they do to avoid having their family involved in estate litigation later, and also having someone objective to talk to flesh out some of these things. Clearly, this is not just a legal problem. A lot of times there's, family and emotional things to discuss. And I think you've really demonstrated that you're up to the task to evaluate those things. So Lauren, if anybody wants to reach out to you to get more advice, how should they contact you?
They can contact me at my main number of the firm, which is 732-483-6300, or by email, which is lbercik@berciclaw.com.
Excellent. Thank you so much, Lauren. And I will also have Lauren's contact information in the comments, so that if anybody needs to reach out to her to get more information, you can do so. Thank you so much again, Lauren, for being with us today.
Thank you. I'm happy to help. Bye, Christina.
Happy New Year.
You too. Bye-bye.